Let's start with the biggest one, which is the Lindsay Clancy trial. I had on Dr. Roger McFillin on Friday. I republished the episode, so everybody should go listen to it because we did a 30-minute segment on this where he's been following it more closely, but from a clinical perspective, not from a legal perspective. And he gets into I don't know if the word cacophony is the right word. The cocktail of drugs that she was on. This is the woman, Lindsay Clancy, is not accused. She accepted facts across the board. She murdered her 3 kids when her husband was out.
Yeah, one of them was 8 months old, 3-year-old and a 5-year-old.
And one of them survived a few days on life support, and then they pulled him. Murdered them when her husband went to get some
strangled. That's it. The way in which she murdered him is notable here.
With not electrical, but rather exercise rubber bands. And then she slit her wrists and jumped off a balcony, I think head first. She's paralyzed from the sternum down. This was a registered nurse, no criminal history, nothing. And I'll just say it up front. I don't think anybody can do this if they're not utterly psychotic. But the only question is a distinction between psychotic and not guilty or not responsible by reason of insanity is a distinction. Someone can be psychotic and still know what they're doing is wrong. And I say one way or the other. Jail for the rest of her life or institutionalized for the rest of her life, and however you want to qualify it, if it makes you feel better, say guilty but insane, which no longer exists under American law. All that said, this is a woman who gives birth to her 3rd kid, is having issues, basically ends up on a cocktail of drugs, some of which are more or less serious. So there's Benadryl, Zoloft, Ativan, and I think by all accounts goes into a state of delusional, what's the word when you think people are coming after you? Paranoid, psychosis. And then she, leading up, hearing voices in her head, she kills the kids. They go to trial. Now the only question is going to be, does it meet the definition of not guilty by reason of insanity? People are going to have some questions, Robert. Maybe you can flesh this out better than me. In the history of the U.S., there was a transition from, they once upon a time had a definition called guilty but insane, which from what I understand, they no longer have as a legal determination. It's not guilty by reason of insanity. There's no room left for guilty but insane. Flesh out what they need to prove, what the legal standard is for not guilty by reason of insanity, and what you think, broadly speaking, of what evidence has been adduced in this trial and where you think it's going to go.
Yeah, the main differences for her is sentencing-wise, whether she gets life in prison without parole under Massachusetts law, or whether she gets detained in a mental health facility where a judge has discretion to not impose that, or to release her every year or so, based on whether or not she has a continuous mental defect, and that mental defect makes her dangerous to the public. So a big potential consequence, because she could be out right away if she's found not guilty by reason of mental defect. Now, the way the law reads in Massachusetts is it's whether you're not guilty because of lack of criminal responsibility by cause of mental defect, and that doesn't require any burden of proof on the defendant. It requires the prosecution to prove beyond a reasonable doubt that she could legally and morally appreciate her actions if she did indeed have a mental defect. So one is to argue she didn't have a mental defect. The second is for the state. The second is to argue even if she did, it did not deprive her of the moral and legal capacity to know that her conduct was wrongful. And then the third is, even if she did have a mental defect, and even if it did deprive her of the capacity at the time of the actus reus, what the mens reus was, whether or not if she was voluntarily intoxicated. In other words, if she deliberately took a combination of prescription medications, knowing it produced a substantial risk that it would deprive her of the mental ability to realize what she's doing at the time she's doing it, then too she's guilty. But they have to prove that beyond a reasonable doubt. The historical example here recently is Andrea Yates. Andrea Yates in Texas claimed that she had to drown her 5 children because that was the only way to save them from going to hell. She was initially found guilty because a prosecutorial expert got the dates wrong of when a video was shown on on one of the I think it was Law and Order. One of the TV shows featured somebody doing this and claiming they were, because of postpartum psychosis, mentally ill. It turned out that show was based on the Andrea Yates incident and came after the Andrea Yates murder. So that the Texas Court of Appeals then reversed the verdict, and on retrial, she was found not guilty by a Texas jury by reason of lack of criminal responsibility. In some states, they call it mental defect. Some states, they call it insanity. In Massachusetts, following the English common law dating to the 1840s, it's called lack of criminal responsibility. Now, America generally follows the Monotone rule, and this derives from an 1843 case in the United Kingdom, which said mere insanity doesn't deprive you of mental capacity to know the wrongfulness of your action. Mental insanity doesn't mean lack of criminal responsibility. In order for insanity to mean lack of criminal responsibility, it must deprive you of the capacity to understand the wrongfulness of your conduct or to understand physically what's happening. What does that mean? That means I thought I was hitting a grapefruit when I hit somebody's head, right? It's that kind of mental defect. Otherwise, it's a mental defect that I had no idea what I was doing was morally and legally wrong. To be honest, Andrea Yates' defense made more sense within that context, in my opinion, than Lindsay Clancy's defense, from what at least I've heard so far. And the Andrea Yates said, I'm trying to save my children's souls, and the only way I can do so is to drown them. That's not what Lindsay Clancy's saying. She's saying that her doctor screwed up and gave her the wrong combination of meds, and that she was suffering from a psychosis, hearing voices saying she had to kill them. But I haven't heard yet. Maybe I missed it. I only saw summaries and summations of the trial evidence. I was not able to follow the trial, and so in detail. So, but from what I saw, so the closing arguments will be Monday. So that I always recommend seeing that, see how persuasive it is to people. Also for young lawyers and law students, you can learn from watching closing arguments what was effective, what was ineffective, what would you have done differently, what would you have done the same, what would you borrow from what they did. I think for ordinary everyday people, it's useful just on its own grounds, independent of the social controversy concerning this trial, is learning how to make persuasive argument. What did you find persuasive? What did you not find persuasive in the style or structure or substance of the argument? So I think it's useful for those purposes. But I think that it's a Massachusetts jury pool. Leans, more. It appears, I don't know how they chose the jury and what went into it or what the jury is like. But from the social media response, I think the nature of that jury is going to dictate the nature of the verdict, because you're seeing a sharp split. You're seeing one group of people say, you have to be held morally accountable for this horrible act, and that her story is not a sufficient excuse. And then you're seeing a group of predominantly younger women and middle-aged women, be sympathetic to her defense. Even Candace Owens was sympathetic to the Lindsay Clancy defense. So I think the nature of the experiences of the jury and what went into jury selection will likely dictate the verdict. In order to have a finding of not guilty by reason of insanity, or I guess it's not guilty. What is it? But lack of criminal responsibility is how they call it in Massachusetts.
Is it?
That's what the jury instruction will be.
You just need one jury member to come to that conclusion, and you fail to have a verdict.
Well, no, then you have a mistrial, and then you can retry the case.
Okay.
So either way, you have to have a unanimous verdict to preclude. Now, I've long disfavored that. I believe that mistrials should be considered acquittals under the Constitution, but our courts don't agree.
Now, people in the chat are saying she was a registered nurse. She knew the risks of these drugs. There's a distinction in law between voluntary intoxication and involuntary intoxication. And one is you drink a Monster and someone spiked it at the factory and you have no idea there's LSD in it. You go on a binge and you kill somebody, and they say that's involuntary because there's nothing in consuming a drink that would lead you to assume that you could have a psychotic break because of a drug. Eating mushrooms, and if you go crazy and do something, not a valid defense. And people are saying when you take these psychotropic medications, these SSRIs and whatever, you're implicitly acknowledging that there's a risk that it might cause homicidal ideations, suicidal ideations, and whatnot.
Yeah, maybe we'll down the road add a component either to this show or do a separate videos along the lines of famous historical and cinematic and characters, because it's similar to understand the difference between voluntary and involuntary intoxication. The movie Memento, which is one of my favorite movies, in it you discover, I call it memento memory, where a person deliberately is creating fake memories for him tomorrow to act out on things he doesn't have the moral capacity, emotive capacity to do at the time. But knowing he's going to create for the next day for that person to do something evil, thinking he's doing something good at that time. That's a version of voluntary intoxication, if you will. He's deliberately setting up his mind so that his mind will do something horrific because he knows that what he's putting in is false the day before in the movie Memento. So that'd be a cinematic example of that. So the question is, I think the best evidence, we'll see what the prosecution says tomorrow, but the best evidence against her is that she seemed to show planning because she waited for her husband to be gone. It was only when her husband is absent that she does this. Like if you're truly losing it, if you truly don't have cognitive control, and that's part of the argument is lack of control, or you don't have cognitive capacity, then it shouldn't show up with things that suggest premeditation and planning. And then the fact that she's a nurse counteracting how she was mixing and matching the medications, putting her on an above average notice and knowledge of that. So my own view is I think there's the evidence that it will depend on your predisposition, I think, coming in to your degree of sympathy, because I'm seeing almost what seems to me from a distant irrational sympathy that, yes, postpartum depression is very serious. But the degree to which you translate that into saying it's okay and someone lacks criminal responsibility for murdering their 3 young children seems to me a real big leap from one to the other. It's like, hold on a second, that those are 2 different things. So I see even like say women on the right advancing this idea, and so I get part of it is a lack of recognition of postpartum depression, and it's very damaging psychological and emotional young mothers. So I get that. But on the flip side of it, I don't think her being a nurse, her doing this while the husband was away, and the particular unless I missed it, her expert just said psychosis, not psychosis that precluded and prohibited her. That was the Andrea Yates defense. And to give you an example that Andrea Yates sincerely meant it, Andrea Yates, ever since she's been committed to a mental institution in Texas, has refused to even request to be released. So this was someone that clearly lost their minds and really thought their children were going to hell unless she murdered them. I was persuaded of that given her post-trial conduct. Am I persuaded here? At least not from what, again, only seeing glimpses here. So we'll see.
One big correction, and I made the mistake, and Dr. Roger corrected me, is that there was no, barring a mistake, there was no formal or diagnosis of postpartum. And
right.
So in this case,
didn't her expert say that he believed she had postpartum psychosis combined with bipolar disorder?
But there was no diagnosis of either of those. The only issue is
prior to her. Right. I mean, I'm just pointing out, what he's pointing out is that she was not diagnosed that prior to the murder, but her expert has diagnosed her with that.
Why didn't she testify? Like, and I understand the risks of this, but if she wants to show that,
it would be really tough. It would be really, really tough. So I think most likely if they focus group tested this case, I don't know that they did, but if they did, what I have generally found is that it almost never benefits a criminal defendant to testify on their own behalf. That jurors will highlight anything. The jurors that are hostile will highlight anything that it's kind of like the book to movie problem. So when you have a character in a book, you have 100 different interpretations of that character by the audience. Once you put them on film, there's only one definition of that character, and you're going to dissatisfy 99% of the book readers. Same problem occurs at trial. Those people who want the person to be acquitted might have 12 different interpretations of who they are in the jury pool. Once they testify, there's only one interpretation left. So I have generally found it is extraordinarily difficult and disadvantageous for a defendant to testify on their own behalf. Now, maybe Carmelo Anthony should have. His effort at a retrial failed as the truth of that case came back out. But and then I guess that's probably his habeas argument. But outside of unique circumstances, like I thought in his case, his only shot was if he testified. Mm-hmm. But you only testify if you're about a 95% chance you'll be convicted if you don't. I think if they picked a favorable jury, just looking at the social media reaction, though, if she has her kind of jury, she gets acquitted or at least a mistrial. If she doesn't, then she gets convicted is my prediction.
For those in the audience also, the fact that she was psychotic doesn't mean that she would not be criminally not responsible for the intent if she knew what she was doing was wrong and went out of her way to try to conceal it or do it when her husband would have been there. What I just, to put a bow in it, just to go back to highlight the insanity of the people out there who were playing sleuth online and suggesting maybe her husband did it and threw her off when he got home. Look at her husband's eyes. He terrorized her or psychologically abused her into a form of psychosis. I mean, this is what we've gotten into in terms of people's propensity to manufacture conspiracies when they don't exist and propose insane theories with absolutely zero, social consequences for having put idiocy out there.
Well,